Thanks so much for attending. We really appreciate it. We focused this webinar on the CPAs in light of the tax season. We've got a lot of technical pieces. We're going to move from domestic to international, from LLCs to trusts. We think you'll really enjoy it. We really appreciate our relationships with the CPA community nationwide. CPAs are our greatest referral source, and we look forward to you contacting us with any questions. So let's get on with it. We will cover some general pieces of asset protection, how it works. We'll start with LLCs, and then we'll get into how trusts work, the history of trust, and maybe how they integrate in certain circumstances with the LLC. We'll talk about some general taxation that most CPAs don't come across on the international side and compare it with some of the domestic, both for individuals and trusts. And we'll provide really a CPA-focused Supreme Court update. In 2024, unlike almost every year prior, you did not have this kind of significant tax cases that will really impact the tax structure, how taxes are viewed, and the challenges available to a variety of tax statutes and regulations. So in this section, we'll get into some generalities. A lot of times CPAs ask us, well, why do we really get involved with asset protection in terms of protecting things that are otherwise available if someone does something wrong? In other words, CPAs are typically highly ethical, we found, among the most ethical people in society. And why are we worried about protecting in litigation? Well, the reality is that you don't have to protect. In other words, if you do asset protection, you can decide if you've done something wrong to pay a plaintiff. What asset protection does is it pulls the existing law to your side of the table and then allows you to negotiate with respect to collection on some indebtedness or litigation. It's protection against future litigation. It's not hiding or anything like this. Also, there are a lot of accusations made, and accusations tend to go away when you have asset protection and there's no substance behind them. The basis for asset protection comes from four areas. You title assets, which in Florida, for instance, we're allowed tenancy by the entireties, which is a husband and wife titling. It's a unified titling, both husband and wife as almost a single person. The single entity can title assets, both real estate and personal property. Some states only allow real estate. Some states, have interesting rules because they have both community property and tenancy by the entirety. Florida allows it for both. But what's interesting about titling with tenancy by the entirety is that if the plaintiff does not have a claim against both husband and wife, then the claim does not stand. You cannot reach the asset, both husband and wife. TBE doesn't occur. There's a lot of misconception on TBE. TBE does not occur just by titling in TBE. You have to actually meet the entireties, which have a lot to do with the idea of control by both husband and wife from the moment the asset is acquired. So if wife goes into a marriage with a bank account and adds husband and calls it TBE, it's not TBE. You have to follow those what are called the entireties. Then you have exempt assets, which are assets you can buy individually, where there's a statute that says if you're sued, you don't lose the asset. Typically, these are insurance-based products or they're retirement accounts, both federally and statewide. Florida, we have very wide exemptions. You just have to be careful with some of the products. In other words, for instance, in Florida, we've got mostly Florida CPAs on the line. If you are not the insured, but you're the owner, it's not an exempt asset. So if you're not the insured, but you're the owner and it has value, it can be taken from you. For instance, and we'll get into this with one of the cases that from 2024, if you own stock, I mean, you both own stock, two partners. If each partner holds a policy on the other, so this covers issues, an unexpected death, this type of thing. Sometimes they actually buy non-term policies. They'll buy a whole life policy that grows in value or something like that. Well, that one partner A is buying insurance on partner B, but that's not exempt. So if partner A gets into trouble in litigation, that asset's available to the plaintiff. So you have to watch the exemptions. Trusts are the historical asset protection vehicle. What trusts do is they divide title. So if a client puts assets in trust for a child, for instance, in Florida and picks a trustee, that asset now is titled for legal purposes with the trustee, let's say a brother or a sister. Legal title rests with the trustee, but beneficial title rests with the child. And grantor, the client, is out, is unrelated to it. So if grantor is sued, there's nothing to get. If the trustee is sued, there's nothing to get because the trustee has to only distribute for the benefit of the child. If the child's sued, you have a trust fund baby. So the trust fund baby can't reach the asset if the trust is set up properly, so there's nothing to get. It's very, very strong asset protection. We'll get into some of the new type trusts where you can set up a trust for yourself in 20 states in a few slides. And then you have LLCs, which are a business entity, but are much more protective than corporations. Corporations, if you own stock in a corporation, it's unprotected. If you're sued, you lose the stock. There's no protection of the corporation. LLC, generally the only thing someone can get, there are exceptions, we'll go through some of those, is a lien on the LLC interest, so distributions cannot be made without the plaintiff getting the distribution.
Gary, a quick question for you.
Yes.
Does tenancy by the entireties also apply to same-sex marriages in Florida?
Yeah. Yeah, as long as it's a legal marriage, you can do the tenancy by the entirety. And we've done that many times. So you
Thank you.
can
Continue.
enjoy that protection, sure. For some background, for some basically accountants sometimes like background with respect to these LLC. So the corporation can be taken. The reason people form the corporation is, you can operate the corporation and whatever happens in terms of the corporate debts, liabilities, etc. Someone falls in the store, corporation borrows without a guarantee. That's all corporate. There's no way to really, essentially no way to reach into the assets of the shareholder. That's true for Apple or Amazon, any stock, or your local grocery. There's no way to get to the owner unless you have a misuse like alter ego or fraud. In other words, someone's using the corp as their own piggy bank, which is just stupid. Usually they don't have a CPA at that point, or it's just some kind of fraud, which you rarely see actually. Reverse veil piercing, I have listed here, is when you have a suit against an owner and they want the asset. Well, we know they can take the corporation. With the LLC, that's the reverse getting into. It's hard to get to the LLC. That's why we use LLCs. We'll get into that. And so the inside protection is where you're not sued for operations in the entity. The outside protection is where, if in fact one of the owners is sued, that you can't get into the entity. That's not true of corporations. It is of LLCs. So, a lot of times what people did for about 100 years was you had shareholders agreements where, oh God, you're going to get sued. we're going to buy you out. Well, that sometimes works, sometimes it doesn't work, but that's a real drawback of the corporation. There's no way to keep somebody out.
Gary, we have another question. Does an entity that is an LLC but classified as a corporation, 1120, enjoy the same benefits and of protection just by the mere fact of it being an LLC?
Yeah, it does. There is one in Florida, you're fine. It's totally an LLC there's no negative case on that. There is one case in Wyoming, which is why we tend to not use Wyoming anymore. Where they kind of ignored that. They kind of ignored that. But yeah, if you're called an LLC, it doesn't matter how you're classified. And Wyoming, by the way, was a disregarded entity. That's just a tax classification. The LLC statute in Florida contains the protections, and that's respected at this point. I mean, I don't think that's going to change. This is some background on LLCs, how they came about, why you have this protection. The protection came from partnerships. The same was true of partnerships with this inability to reach in and take and affect the other partners. The problem with the partnership was obviously that you didn't get the inside. So if something happened inside a general partnership, everyone was liable. So you were forced to do limited partnerships, and then the general partner was liable, and then they had to do a corporation for the general part. All that's gone. So you start to see these limited partnerships and corporate. It's totally archaic. You still see them once in a while though. And that's the combination of the inside and outside liability. There's no minutes or anything like that. The one thing I would say to be careful of is you don't have bylaws, and of course you don't have the shareholders agreement for the LLC, but it's an open frame, it's an open format, and you create your own operating agreement, which has all the rules. When clients or financial whoever is going to start to create operating agreements, it's a source of great business for the litigation firms. It's very, very hard to create an LLC operating agreement or any kind of nuanced rules in those agreements on your own. You just don't want to do that. You want to have a seasoned attorney do that. And so where do you form it? If you're living in a jurisdiction or operating in a jurisdiction that's got a great LLC statute, use your home state. There are a lot of statutes that aren't very good. We hit some of these pieces up here, but there's a uniform limited liability company act that's been adopted in a variety, and adapted actually in a variety of states. You have to be careful because some of these uniform acts are kind of, almost like there's a political background to them. They're not that protective. And you don't want to get into a situation where you're living in the state that has a terrible LLC law and you intentionally expose a client. So you want to pick a law where if someone sues a client, for instance, they can't get it. Some of the acts actually allow for foreclosure of the LLC interest. So that's what you think about when you start to pick these entities. If you pick an entity in another state, you just do business in whatever state you want. At that point, you're doing business in where the business is operated. If it's a family investment operation, you just pick the best state. Then it's a no-brainer. Because the last thing you want is for some very valuable entity to be foreclosed on from the outside. One thing to keep in mind is this internal affairs doctrine. Florida, for instance, has a law. Most states have a case at least where it says if an LLC goes to court on the seizure of equity, and it's an LLC from another jurisdiction, does the courts in the jurisdiction where the case was being brought, did they respect the law, the internal affairs of that home jurisdiction? So that's very powerful. Like if Florida says we respect the law of a home jurisdiction, Delaware says we protect the LLC. Well, we want to use that protective LLC. Do we know what's going to happen? No, we don't know what some of the crazy courts are going to do, but it's better. It's great. It's something. It's a guidepost, at least when we set the thing up. And whatever state you're using, if you have a protective internal affairs in your home state, use the most protective state because it's probably going to be respected. Here's some of the issues that come up. We have some interesting cases that give us some guidance. When you have a client and you're choosing a jurisdiction, how does it work? What have some of the maniacs done, which give us some insight into what we should do on a prudent basis. This Sabrina Barber was in Florida. She formed a Nevis LLC. I'm actually very familiar with this Nevis LLC, but she did it as a fraudulent transfer. In other words, she was in trouble with Wells Fargo and just kind of shot, money all over the place, which is crazy. And so there's a statute that says if you do that when you're trying to run away from someone in Florida, Florida can go get the money. The plaintiff can get the money. And the court kind of didn't follow that line of reasoning, which I thought was kind of an obvious line of reasoning. What they did is they said, well, you shot it into a Nevis LLC, which is very protective. I can assure you it's very protective. I wrote part of that statute. But we're going to treat it like a Florida LLC. And so they followed a line of cases that really stemmed in bankruptcy from the 80s and 90s, where we said, well, you're here, so that's there. And so we're going to treat it like it's here. And so they took her LLC. I don't know how that works in terms of legality. I think they could have done it easily with a fraudulent transfer action where they just grab what was transferred. Interesting about on the Barber case, she left all the assets here. Yeah, so the court's going to be tempted to take, whenever you leave the assets in the jurisdiction of litigation, the court's always going to be tempted to take it under whatever, cause of action or right or collection obligation they want. It goes into this JP Morgan case where there was litigation in Arizona, and the defendant had an LLC in Colorado. So now you have the assets are in Colorado, not Arizona, where the litigation is. So the plaintiff received the judgment in Arizona, goes to Colorado. Now we're in Colorado, where the LLC was formed, and they nixed the plaintiff. The plaintiff was not allowed to reach into the LLC because now we're talking about a Colorado LLC and a Colorado case. So typically the judge is going to enforce its own rules. In the Barber case, Florida court was like, well, this is some Nevis LLC offshore. We're just going to kind of do, my impression is we're just going to kind of do what we want. We also had an interesting couple of cases where, for instance, in that Wells Fargo case, one of the issues was, well, the certificates associated with the Nevis LLC weren't created. And if those certificates were created and they were offshore, well, that might have created an issue whereby under the Sargent case, which was a case right at the same time as Wells Fargo, right before, if the certificates are offshore, you can get your judgment in Florida, but you got to go to the jurisdiction where the certificates are, which of course are going to keep moving from, it doesn't work. And so that's what Sargent was sued on, that had the certificates offshore. Actually, it wasn't Sargent, it was Alsala, the defendant, was sued on that. And the certificates were like in the Emirates, and the court said, you got to go to the Emirates to collect. And all the litigators went crazy until this case, Shim. And in the Shim case, the defense is like, well, I'm just going to go under Sargent. I'm going to lose here in Florida. So what I'm going to do is I'm going to take all the assets and I'm going to buy an asset, a paper asset in Korea. And I'm going to go under Sargent. It's in Korea. You've got to sue me in Korea. Court said, I don't think so. So essentially, the standard was before Sargent that you could force a defendant to now bring back those certificates or that asset into Florida to pay the debt, right? Under threat of incarceration, right? Civil contempt. And so they didn't do that in Sargent. So they did it in Shim. They said, well, look, we're gonna put you in jail until you give up the financial asset. What typically happens with the standard, white collar, issue is the guy's like, okay, I'll have it to you 20, let me FedEx it over. And that's the end of that, and they pay. So that's changed in Florida. The Supreme Court upheld that. And so you can't just play, the Ponzi scheme with the stock certificates anymore and move them offshore to avoid collection. If you have any questions on this, let me know. I know I'm going pretty fast. I just want to make sure you have a good background with respect to this kind of generalized CPA overview.
We do have one question.
Okay.
Does a classification of an LLLP, three L's,
Mhm.
create additional protection from the classification of an LLP? I see
Yeah,
some doctors and real estate investors using LLLP.
yeah. So that's antiquated. You would never use that today. I mean, I don't want to say never, but essentially never. You use that today. There might be some instance where you might like it. So what happened is you had the GP, which is where everyone's liable, and then you had the LP, which is a limited partnership, right? And so the limited partnership, the general is still liable. So you have a general, usually organizer, manager, or whatever. And so you have to put a corporation there as a general partner to kind of limit the ability of someone to get out of the entity into the pockets of that general partner. So the whole thing's kind of difficult. And so they came up with this idea of LL, right? So you can have an LLP, which is a limited liability partnership, which is two people. They're in a general. Now they file the LL. Now, right, they're not liable for what goes on in the partnership. This was kind of put in place while they spent 3 years negotiating whether or not to adopt the LLC statute. There's no reason to have an LLP. So LL was also put on LP. So you got LL, LP, and thus the general partner is not liable.
We have one other question,
Just
Gary.
being LLC.
Is there a website where we can compare the different state jurisdictions?
I don't know of a website actually. There's some comparison with the domestic asset protection trust, which we'll cover in a second. But I don't know of one. I don't know of one. If they want to send um me the email, I do cover it. It's got some age on it now. But it's about eight, I think it's about 8 years old in the book. I've got a book on a comparison of jurisdictions. Um, and I can send them the book, no problem. So they at least they can get a flavor for how the thing works. And that's where are we now? Choice of law. So we get into the choice of law and some of this stuff we're going to cover with trusts in terms of these three pieces here. But one overriding issue is I can't get to the asset. People say I can't get to the asset. Someone else is owning it, or someone else is managing it, or someone else is a trustee, and that doesn't really work if you're running away from a creditor. You created the problem, so you have to deal with it. So one thing, it's interesting to take a look at the where the courts kind of ended up and how chaotic it is. It gives you some insight as to the fact that you have to be very conservative when you choose your jurisdictions, and you don't want to have any problems going on. In this case, Arroyos, essentially had a case in Maine, and some of the assets were in Alabama, but the LLCs owning the assets were in Delaware, formed in Delaware. And the court kind of threw up its hands. It's a federal case. The court said, I'm not going to rule on any LLC that's formed in another state, which doesn't make any sense at all. Any court can rule on a statute of any other state. That's not a problem. It just gives you an idea that if you plan, in this case, that Delaware LLC probably will hold up. But if you plan and you create these structures in a sophisticated way under the current law, you're going to be at a significant advantage, especially in one of these situations where the judge just kind of like, I don't know how this works. I'm going to punt. It's going to create a lot of costs for a plaintiff. Which is right? We don't really know which right. I can tell you that Arroyo's was more of a standard case. Barbara was a fraudulent transfer case. Fraudulent transfers don't really work. You really have to get to this stuff before the clouds form. If you get it before the clouds form, it's very effective. We have not to this date, we've never had an asset protection plan breached. I've been doing this for 31 years. This is a single member LLC, which really hits the plate of a lot of CPAs. We constantly have questions on that. We welcome questions from CPAs anytime. We get a lot of work from that. There's no fees. We have clients call. We do not bill for calls, these kind of inquiries. Just want to put that out there and make that absolutely clear. So the single member LLC, what had happened was in bankruptcy, you got into this situation where someone had a lot of assets, like this Ashley Albright, this movie star, and she had them in single member LLCs. But the LLC statutes kind of protected everything. They didn't talk about single member LLCs because I don't think the legislatures at the time had any idea. They were just like, well, they're all protected. They're all just, you can only get a lien, a charging order. You can't take this equity. And then the bankruptcy court's like, well, we know they say that, but we really want these assets. That wasn't the intent. If it's a single member, that's not the intent. The intent was to protect the other member who's not part of the litigation. That, of course, in many ways, had nothing to do with the formation of these LLC statute, but that's the way it developed. So you had the exposure to the single member LLC. This first case was Albright in bankruptcy. You later had a Florida case. And Florida, I thought, just botched the whole opinion. It wasn't a bankruptcy case, but it was a criminal, and they wanted to get to his entities. So they kind of threw out the baby with the bathwater. They had to redo the whole statute. But they really never reinstated the protection on the single member LLC. It's not that strong in Florida, the single member LLC. It's got a lot of weakness, just so you have a little background on that. They did correct the multi-member LLC. Nevada is also very good. Delaware is very good. Wyoming, I had mentioned, there's some problems with the case there. The idea now, if you have a 99-1, is that a single member? We really advise against like a 99-1%. We had this case, Curchi, where a very wealthy guy, let me check the time. Oh, we're doing fine. We had a very wealthy guy in California get a little too cavalier. He was making huge distributions out of a family LLC structure, got into some kind of debt and kind of stuck his tongue out at the lender. And that's just a mistake. I mean, you get too cavalier, you mess with the court gets upset, and this is how this stuff happens. So he said, you can't get anything. I've got this multi-member LLC, it's completely protected. The debtor's like, what am I supposed to do? This guy owes me the money. And so the court starts to chip away at it. The trial court kind of said, well, you can't get it because we don't allow people to come in from the outside to take equity in a corporation. That was a completely misguided analysis because corporations are just totally available. You just grab the corporation. So the court used that idea to say, no, LLCs are different. And in this case, we have a guy who's totally in control. There's nobody else involved, and he didn't even take his interest with the wife by the entireties. So it's 99-1. So we're going to say, you know what, we're going to send this back to the trial court, and we're going to let them come in and grab the assets or grab the equity. So we don't want to have this completely onerous situation. When we could do TBE, we can if we can create significant other members, even trust for kids or other members. It's very, very helpful. You don't get into this situation in general. And I don't know why Delaware law was not implicated in this case, but it just goes to show you that, you know, if you're kind of difficult with the courts, you're probably going to pay the price. And that's happened here. You had a black letter of the law kind of filed in this Glick case. They did not allow it, you know, trust to be broken into. The LLC. It was a trust with an LLC to be broken into. You add trust for the members. You know, you add kids, you add whoever. You can still, in many ways, keep some control over it. You do have the accounting does become a little more challenging, which is great for you guys, the CPAs out there, when you have like, you know, 8 or 10 different structures and all kinds of kids trusts and everything else. But it is protective, and once you set it in place, it kind of runs itself. You know, you got to keep in mind that a lot of times we combine trusts with LLCs, and we'll hit that in a second. Some of the offshore, if you got a client, for instance, that's selling in an M&A transaction, or you have a foreigner, sometimes we like to leave assets behind so that they're not subject to the estate and gift tax for foreigners. Some of the foreign LLC and trust statutes are really, really protective and easy to deal with. We love this Nevis. On the LLC side, it's very, very protective, and you know, fraudulent transfer actions are very limited. It's got some very quick statute of limitations. But I would say the idea is that if there are foreign assets, we use a foreign entity. Usually that's the case. Otherwise, the courts are very tempted to take US based assets, even though they're in a foreign entity. It's really very protective, but the idea is that the Florida court doesn't have jurisdiction over the foreign entity, and it's incredibly powerful. No way to get to the assets. You know, we talk about a lot of the detail with respect to the statute. It is protected, but underlying issue is the court can't rule on those assets. We talked about Wells Fargo and Barber and Sargent and the Shim case with respect to fraudulent transfers. We're not going to get involved with that. Shim is this moving certificates around is no longer really available. Obviously, with these foreign LLCs, there's more reporting. You've got the FinCEN and the FBAR. We'll hit that in a second. This is Barber again. And then we talked about TBE, fortifying the LLC on top with a TBE. What if we have a single person, a non-married person? Well, if that person has an LLC, we run into the single member issue, especially in Florida or in a state where you have one of these bankruptcy rulings. Well, we often drop it into a self-settled trust. So we'll get into some of the background with respect to these asset protection trusts, but there's really not a lot of drawback to doing that. In other words, if someone has it in a single member, they're either going to get foreclosed, or if the plaintiff puts a lien on there, they can't get any money out. So we drop it into a self-settled trust, which we're going to cover now.
Gary, we have a question. If 99% to 1% is not advisable, what is a reasonable safe percentage for multi-member LLC?
Well, we typically advise, you know, it's kind of related to how many other members too. This is just kind of rule of thumb. We don't have any case law on it per se. But if you have like one child trust, you probably want to do 5%. If you've got 4 kids, can you do 4%, 3%? Probably. What happens is, like, we were asked to do one a couple weeks ago, 0.02%. You know, that's not, no one's going to respect that. What happens in the court is, not only is it not respected because it's silly, but it looks like you're abusing. So as soon as it looks like you're abusing the system on this multi-member, they completely lose any respect for all of it, and they kind of throw it all out. So let's try to stick with around a 5%. When we deal with these trusts, we've got different kinds of trusts. Every week someone comes in with a revocable trust and says, I'm all set, I'm protected. Revocable trusts are essentially fancy wills. They don't do anything. Typically, if you can't convince the client because they just don't know or they were misled, you have to kind of bring them back to the idea, can you revise it? Can you change that revocable trust anytime you want? How can you get protection from something you can change anytime you want? It's not protected. And then, the standard trust is for someone else with a third party trustee. If it's spendthrift where the trustee controls all the distributions, that's highly protective. And then we get into this asset protection trust where you create your own trust. So now we have 20 states now that allow you to do this, right? If you're single, especially, and you're going to be subject to a charging lien on that LLC, what options do you have? And really the only option domestically is you create your own trust. You put your LLC interest into the trust. You create an irrevocable trust for yourself. You can have secondary beneficiaries for kids. You give kids trust, they can have their minority interest in the LLC. So it's we like Nevada trust with the kids trust. You've got a multi-member. And the Nevada statute says if the client's sued, they can't reach in, they can't get the assets of the trust. That's the kind of the best they can do domestically. I'm sure I'm going to have some questions on this, and feel free. So it's 20 states. This is some of the background. We don't have it in Florida, none in Georgia. We have a lot of clients in Georgia, Atlanta area, none in New York. So we do have a few cases on the domestic asset protection trust. One is this Uber case, which is a bankruptcy case. So you have to take bankruptcy cases with a little grain of salt because the judges are so much more aggressive in bankruptcy cases. But essentially, this was a developer who had no connection to the trust. The assets were in Washington State. The co-trustee was in Washington State. He was in Washington State. And then he went bankrupt. And there's a line of cases in bankruptcy which kind of says if you kind of lose the connection to the trust, we're going to apply the law of your home state. And Washington State doesn't allow self-settled trust, so we're just going to take it. And that's what they did. And then this Mortensen is it's kind of a wild case where a mountain man created his own Alaska trust. He did have the connection to the trust. He was all set, really. Had some debt, had a divorce, and someone, or he maybe did it on his own somehow, he filed bankruptcy. So he was out of the statute of limitation. What happens with fraudulent transfer is if you transfer assets and enough time passes, no one can claim, oh, he was transferring to avoid me. Once the 4 years pass, most states are 4 years, you can't claim. You can't get to those assets anymore. But when you file bankruptcy, it's extended to 10 years. So he filed bankruptcy, extended out the statute, and lost all the assets. Some of these are, there's some technical requirements with respect to the trust you have to file. This is Bertrand. It has to be real. You can't retain powers, absolute powers over these trusts, or they become non-irrevocable trusts. And that doesn't work. That's a Tennessee case in bankruptcy. Eric Steen. Kilker was a developer who kind of upset the court. He was out of the statute of limitations. They didn't care. They cracked open his Nevada trust. I don't know of another case like Kilker, though. Nevada trusts have done pretty well where the statute of limitations have run. And then we combine them with the LLCs, like I had mentioned, especially if you're a single person, you hold your LLC interest, which gets the charging order protection in the trust. And then you do it before you have any claims, you're probably going to be in pretty good shape. We can do the foreign for foreign assets. We can do the domestic for domestic assets. When do you do the foreign? When you absolutely want a bomb shelter type entity and you're going to use foreign assets. We do a lot of foreign with respect to business sales where they have an indemnity period. These are some of the basically benefits of foreign trusts and some of the technical requirements of the statutes to collect against the foreign trust. This is an older chart, but gives you a flavor for some of the benefits. Obviously, this presentation is going to be available to anyone. All we need is an email we sent to you. You want to select a corporate trustee. This is just kind of security type things. There's significant compliance, which we'll hit. And this goes back through some of the cases, same cases. This is the Rush case where the family decided not to give the money to the hospital that had been promised to the hospital in Chicago, Rush University. And the court was not happy with that. So what the courts do sometimes on reliance is, even though some of the assets are in a foreign trust, they'll take local assets, even though the assets in the foreign trust were pledged that the court can't reach. That's what happened to Rush. This is this alter ego. We don't want to do fake things or sham things. Obviously, CPAs are going to obviously avoid that like the plague. It becomes really obvious that someone's faking it or doing it for the wrong reasons. And this is just some of the pieces. This is the impossibility where you're running away and you throw something into a trust. Now, some of these where you had a fraudulent transfer, actually the trust is upheld. This BB&T case, very interesting, where the guy, well, he was saying we weren't really running away. He had a number of reasons for using the trust structure, including health and problems, and the fact that he actually was secured in other ways. It becomes very nuanced, but you really don't want to have a situation where clouds are forming and you're running away. Otherwise, it's very straightforward. It's usually very straightforward. And you want to create that connection to the assets, which I had mentioned before. This is the keys to affecting this. I'm rushing through a little because I want to hit some of the other slides. I know you want to hit taxation. And I'll take any questions. If we go a couple minutes over, that's okay too. I wanted to compare some of the foreign with the domestic, which very few CPAs deal with. This is the unified credit on the state and gift tax. Obviously, it's become very large. We get this $28 million credit. We can turn that into usually about a $60 million benefit if we use the right estate planning strategies. So if you have highly wealthy clients, you think they're going to have a taxable estate, there's a lot you can do now. And they can keep the income, which usually solves the problem. They really just want that income every month. If they require $50,000 a month, that's okay. Some of the clients require $500,000 a month. We can do that too. It actually can be very helpful to retain income, believe it or not. This is some background on the estate tax. I know most of the CPAs have some. It's basically at death, you have a gross estate, and whatever exemption remaining is going to be applied. The gift tax is on single assets gifted, whereas the estate tax is inclusive on the whole thing. And I wanted to get to some of the comparisons. When we plan, we sometimes complete the gift to get the asset out of the estate. Sometimes we don't complete the gift, and we'll go into why we may not complete the gift on, for instance, a foreign trust. This is just trust with they file an annual return, they pay their own tax, they have their own interest, income rates, which are higher. They get to the higher rate a lot faster. And then who's a U.S. income taxpayer? Who's a foreign taxpayer? So U.S. persons are citizens and residents. What's a resident? A resident is established under the substantial presence test. It's basically you're here more than half the year, or you go into if you're here many years, there's a weighted average of the last 3 years. And the magic number is 120 days. So every Brazilian in Florida knows that if they're not supposed to be here 120 days, because if they get out in 118 days, 119, they're not subject to the substantial presence test. And once they're a resident, they're like a citizen. They're taxed worldwide, which is not what they want. The estate tax, it's worldwide, but the standard is totally different. You landed here and you intend to stay here, even if you've only been here for 30 days. It's not the same standard. And you have to work that standard in the planning. You have to strategize what the client needs and then the amount of time they're going to be here and what exactly their intentions are. And these are some of the exceptions to the income tax. So foreign people do not pay capital gains tax on stock sales. No capital gains tax on intangibles. Amazing exemption that a lot of people don't understand. Of course, there are treaties that can reduce the amount of tax. The withholding on passive income, interest and rents and this type of thing, 30% at the source. You have a lot of withholding agent issues that come up. And then you have graduated rates, and then you have real estate, which can be kind of tricky. It's essentially treated like our capital gains asset, but almost all these people hold it in an entity, right? And the entity, you hold it in an entity because it's for whatever reason the client dies. You end up with an estate tax. The other thing, not the income, the estate tax on the real estate. So the entity though will change the rates, will change the income tax rates. It's a nuance that you have to be very aware of. And then on the estate tax side, am I US? Am I foreign? Do I intend to stay here? Right? So what we do is we gift intangibles. You can gift intangibles. There's no gift tax. Be careful with the gifts, though. You want to make sure you do it right because there's no unified credit between spouses, and the spouses cannot. There's also a limit, even if you have a U.S. spouse. I hate to get too deep into the weeds, like it's a different seminar, but the treaties will apply. And if you die with a bank account, it is not subject to the estate tax. So you have to keep in mind in terms of variables. Is it a foreigner coming in? Are they buying US or foreign assets? Is it someone in the US or a resident of the US who intends to stay? What kind of assets are involved? Keep in mind with respect to the assets, very rarely that the people actually go through what type of assets are involved. But if you have a very wealthy person, for instance, in another country that may come into the country, we had done a Florida bar article on this. If you need, just let me know. Well, you may have beneficiaries who are foreign and beneficiaries who are US. US beneficiaries pay tax on worldwide income, right? So if you've got US assets, you will probably want to set up two trusts, one benefiting the US people because they're going to pay the tax anyway on the US assets. But the US assets are going to be taxed to the foreign beneficiaries as well. Whereas if you have foreign assets in a foreign trust, the income associated with those assets is not taxed to the foreigners. So you have to be aware of which assets you're dealing with. And this is the NRAs, the non-resident alien, are only taxed on their US source income, right? But when they die, there's only a $60,000 exemption. So you want to create a foreign entity to hold all US assets to avoid that state tax issue. And we do that all the time. In terms of foreign trusts, what is a foreign trust? You get into this, what is a foreign trust? And so if you have a foreign trustee, basically, right? Or it's set up as a US trust where it's a US court can govern it. It's US law, US court. If you fail one of those two, so if it's not governed by US court or a foreign person manages it, it's a foreign trust. And then you, of course, you guys are familiar with FATCA and FERPTA. And so you get into this foreign trust. You could have a US Delaware trust that's got a foreign trustee. And now it's a foreign trust, you've got to comply. Now, in some cases, you might want that taxed as a foreign trust. If you've got, sometimes you've got foreign beneficiaries, or there's a variety of reasons for that. But that's one way to manipulate it, by having a foreign trustee. On the income tax side, if you're US and you put assets abroad for yourself in a foreign trust, there's no change in income tax. It's disregarded. It's a grantor trust. But when you die, those assets are subject to mark-to-market deemed sale. It's like the expatriation tax, unless they're in your estate, right? So the same thing happens with foreigners. You want to create that foreign trust, but you have to wait 5 years. If you don't wait the 5 years, when you come up, the same thing happens. So if you have a US beneficiary on your foreign trust, you're not taxed on mark-to-market, but when you die, you've already gotten those assets out of your estate. So when you die, there's a capital gains tax on all the trust assets. It's a terrible trap, just to be aware of, on these foreign trusts as a red flag issue. That's 679 and 684. And this has to do with DNI and some of the income tax issues associated with trust. That's distributable net income. If you don't distribute, there's also an accumulation tax that occurs. And then the treaties may have some impact. The treaties, I find, are much more helpful on the income tax side. They're either domicile based or they're situs based, which means they're where the person is, taxes, domicile, or they're the individual assets, the situs of the assets. And this is the compliance issue. You've got this 3520 that involves foreign trusts and foreign assets. And so if you have a trust, for instance, the trustee files as 3520, the beneficiaries have to file, the grantor has to file, and it's a matching format, 3520. And they call some of the attachments 3520A, which is the trustee, but it's all really the same. So they're making sure all of the parties have given all the information with respect to the trust. And most of the CPAs are totally aware of FATCA and FinCEN, which require, if a US person has a foreign account, you have to report the foreign account. It's a little bit different, the standard for the foreign assets like securities versus a cash account. A little bit lower standard. And let's go into, to close it out, let me give you a few minutes. I've got, I went over, of course, but I thought most of the CPAs might want a little SCOTUS update. The first case is Connolly, which comes up all the time, actually. It's not a foreign issue. It's when you have a cross buyout. In other words, if you've got two partners, or actually you got a number of partners. In this case, it was two partners, brothers. And it said essentially that if one of us dies, the corp was going to buy out the decedent, right, as a redemption, with the insurance that the corporation maintained on both shareholders. So there was an old case that said, well, if insurance pays, then when the decedent's estate files the estate tax return, the insurance value doesn't count in the value of the company. So it's a lower value, which is great. And because it's going to go out, and then proceeds are going to get paid, and then they're going to take the stock out, and then there's going to be one. So it's accounted for. It's really incorrect, though. As the CPAs know, you got a balance sheet inquiry. And so if cash didn't come in to buy out the deceased shareholder, it would be a promissory note, right? And that promissory note would be a debt of the entity, right? But the key to it is the accounting issue. And the accounting issue is you've got a redemption. So now you have a concentration of those assets in one shareholder. So it's a kind of a quid pro consideration, and that you have to count. You have to count the insurance proceeds because that otherwise would have been a promissory note as a balance sheet issue. So they kind of corrected the old Blount thing. So now when you have insurance proceeds pour in, they count. So what's the answer? The answer is cross purchase insurance. Have the two shareholders cover the insurance. It is an expense, guys. We know it costs money to buy the term insurance, but man, when it pays in, you get that concentration of value, right? And you don't get a kick up or a promissory. You don't get a kick up in the estate tax on the deceased return, and you don't have to worry about insurance. You don't have to worry about dealing with the insurance coming into the company. That's Connolly. A very technical case more is a throw off of the CFC changes that occurred under the first Trump administration, right? So if you follow this, essentially Trump said you have these CFCs. If you have a company abroad where you control it, a corporation, a controlled foreign corporation, if the CFC rule said if you've got subpart F, you're basically, if you reinvest non-active income, basically you're making money, right? And it's going to become non-active, but you reinvest that money, you don't have to pay tax. That's the CFC. So you have all these people investing in foreign companies and they're reinvesting all the proceeds. That's a CFC. You're reinvesting, you're not subject to tax. The GILTI tax, which was imposed under that administration, says no. You got a minimum tax at roughly 10%. You can't do this anymore. Can't do this anymore. That was kind of the overview to the 2017 Tax Cuts and Jobs Act. In this case, we had investors in an Indian company. It was a CFC. It was owned majority by US people, and they were just reinvesting, so they didn't have to pay tax. So there was a claim by the IRS under this new act. No, we can go back under this mandatory repatriation part of this 2017 law and say, look, all these prior years that were closed, we want the tax. I thought this was, when it first was filed, I thought this was a little bit of a push because like when they created these CFCs and all of this income over the years, I mean, the law was totally different. So I thought it was a little bit of a push. So it kind of came down to this idea of it's a constitutional issue, which was its own seminar, but essentially was that income realized at the time? And Kavanaugh, who wrote the opinion, said, we can't do double taxation, but it's just like a pass-through, really. Of course, at the time they formed it, the law was different. It was no pass-through, it was CFC, and those years had closed. And so he's like, no, it's not double taxation. They did realize the income, and we're going to tax them on it. So they let them tax it. I don't know. I think they went a little far out there. Of course, these constitutionalists, Thomas went crazy because in some sense, the basis for it may have been a little questionable. And Justice Brown, we just want to throw that in there. She had no problem with it at all. She was like, well, there's really no limitation on the power to tax. So, take your position. This is we're going to do another article on the kind of the positions, the nuanced positions in a summer bar article. We're prepping now, but it's an interesting opinion, if nothing else. And then Loper Bright, I'll close out with this Loper Bright. I won't hold you past an hour. Is a really serious opinion, actually. It's not a tax opinion. It had to do with federal regulations. They dealt with shipping companies having to pay for an observer so they don't overfish herring or something completely nothing to do with tax. But the court there was a challenge to the regulation, which was Chevron. Chevron says the particular agency can make regulations, right? If there's a gap and that the court, if it's reasonable, the regulation has to follow it. Essentially has to follow it. We can go into the nuances if any of you want to call me on this. But the court said no, no. The court does not have to follow it. The court can use its reasoning and can draw on any expert it wants to overturn any judgment, any regulation, any judgment on a regulation. So all the regs are kind of up in the air. If there was a ruling on a reg that was previous, it's stare decisis. It's ruled. It's not going to get overturned. But you now can challenge these regs. It's going to allow for open season. And that's the end of the presentation. We really appreciate you sitting through that. And we're available for any questions. My contact information is on the slide. If you want the books or any articles, just let us know. Thanks so much for attending.